Welcome to In the Name of the Law, with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinas from Sinas Dramis Law Firm, Brandy Thompson from the Kronzek firm, and Mary Chartier from Chartier Nyamfukudza PLC. Now, let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law. Today, our legal talk show is going to cover some hot topics, like voting for candidates in the criminal justice system, a challenge to the new no-fault legislation on constitutional grounds, and what to do when CPS comes knocking on your door. Stay tuned.
In the name of criminal defense.
2020 is the 100th anniversary of the 19th Amendment, which gave women the right to vote. And it's also the 150th anniversary of the 15th Amendment, which gave Black men the right to vote. So let's talk about voting in the context of the criminal prosecution system. Today I have with me Mary Chartier and Nyamfukudza. Tell me, is voting important when people want to make a change with the system?
Oh, it's absolutely important. It is the most fundamental way that citizens can actually change the criminal prosecution system for the better. And we all have to remember, people actually fought and died so that we have the right to vote. And so many people don't exercise their right to vote because they think it doesn't make a difference, and it absolutely does. Prosecutors, sheriffs, judges, legislators, they all impact the system that Kurt and I work in, which is the criminal prosecution system. And when people don't go and exercise their right to vote, they don't help shape the system into what we really all deserve.
Well, let's break it down. How does the prosecutor impact the daily lives of a regular citizen?
So most people think a criminal defense attorney is the first person who has contact with the file, but it's actually the prosecutor, because that's who decides whether a person gets charged and what they get charged with. For example, in a case involving a firearm, based on the same weapon, somebody can get charged with as many as 3 different counts, one of them being a felony firearm, which comes with a mandatory minimum of 2 years in prison. And something which could be a garden variety retail fraud, sounds fancy, right? It's really shoplifting. Just because an individual swats the hand of a loss prevention officer can then become, if the right prosecutor has the file in their hands, an unarmed robbery. And that takes it from a 93-day misdemeanor to a 10-year felony. So they have great power and discretion.
Okay, so what about sheriffs? How does that impact daily lives?
Well, we're seeing that on a daily basis now with what's going on. I mean, recently that young boy in Utah got shot multiple times. He was on the autism spectrum. His mom called the police for assistance, and then he didn't have a weapon. He got shot. We saw Breonna Taylor asleep in her home. She gets shot and killed. We see George Floyd get killed. So the police and the sheriff who are elected, he is responsible, or she, for the training, the policies, the procedures that go into each department. I mean, in Genesee County here in Michigan, we saw a sheriff actually march with Black Lives Matter protesters. In other communities, some of the police were really at odds with the protesters. They went in there in a very antagonistic fashion. And what we saw in Genesee County was a sheriff who took the opposite approach. And he took the approach of, tell me about your experiences. Tell me about your fears. I want to listen. And I think he even said something along the lines of, I'll march with you all night. I'll listen to you all night. I mean, that's a very progressive sheriff. And I think we saw in that community a real coming together from law enforcement and citizens. There was very little, if any, destruction, no property destruction, because individuals realized they had someone who would listen to them. So the sheriff election is extremely important in making sure our communities are safe, and also making sure that they meet the needs of all citizens. All citizens are treated with respect.
And if I may add very quickly, Mary, to your point about sheriffs keeping us safe, we have some sheriffs who have just decided, I don't care what the governor is going to do. Not just in Michigan, but this is true in some of our counties here, where they say, governor, you signed some executive order saying people have to wear masks. Not in my county. I'm the chief law enforcement officer, so I don't care whether people are prone to catching, COVID and anyway. But to your point, yes, sheriffs can impact our lives in very real ways.
Got it.
And in that situation, I mean, really, we're like one step closer to anarchy when you have sheriffs saying they're not going to follow the rule of law because they disagree with it. Then you have other sheriffs who are following the rule of law. And if we go back years when marijuana laws were on the books and people were being charged and put in jail and prison for really small amounts of marijuana, you had sheriffs saying, well, it's not my job to judge the law. My job is just to enforce the law. So I may not like it, but I have to enforce it. So there's really that contradiction when you have sheriffs saying they're not enforcing laws signed by the governor.
Let's talk about electing judges.
Well, certainly in Michigan, all cases start in the district court. And whether it's a felony or misdemeanor case, that's where they start. But certainly judges, if somebody chooses to run the preliminary examinations, are the ones who say, you know what, Mr. or Mrs. Prosecutor, I don't think you have enough evidence here for this case to warrant this case going forward and being tried. Judges are the ones who decide whether ultimately a person is going to be on probation. And I've said before, it's very expensive to be poor, because while some people think, oh boy, this judge didn't sentence the individual to a term of jail, or if it's in circuit court, prison, they're giving them a break by allowing them to be on probation. But actually all the costs associated with that can themselves, if you cannot pay, irrespective, one example is if you go and you're required to show that you're not drinking alcohol or using drugs, even if you show up, irrespective of how you'd have tested, if you did not have the money to pay, that in itself is considered a dirty drop. So judges have great discretion. I've seen judges give an individual a lot of community service, and they have the ability to waive some fines and certainly take the circumstances of the people who come in front of them into account and keep those at the forefront of their mind. So they're not robots. But yeah, they have a great deal of discretion and can impact people's lives in many, many ways.
So you can always tell a judge, I think, who really likes people by the way they treat people in the courtroom. And I'm always amazed at judges who are just so disrespectful, not just to the lawyers, we're used to it as defense lawyers, but to the people who are there. I mean, that's who they are there to serve. And the other thing too, when you're thinking about voting for judges, I mean, it always bothers me when you see someone say, well, I lean towards victims, or I lean towards families, or I lean towards whatever. They're just really supposed to be kind of the referee in the courtroom. They're not supposed to lean one way or the other. So judges are critical, legislators are critical, right? They're the ones who actually write the laws. They decide what, how a felony or is classified, what the sentencing range will be, what the maximum is. So, I mean, it is so important for people to vote because it really does impact everyone's daily life.
So what about voting for legislators?
So voting for legislators, as I just said, is so important. One of the things I think when we're talking about voting that we want to remember is a lot of people talk about voter fraud, right? In all of our years, you rarely see anyone charged with voter fraud because it really doesn't exist. What you see much more of is voter suppression efforts. What happens in Michigan is even if you have a felony conviction, if you are not in jail or prison serving a sentence, you can still vote. And that's one of the big misconceptions in Michigan. You can actually go and vote, and people should be voting. If they're in jail and they're awaiting trial, and they're not serving a sentence, they can vote. The other issue is frequently, do you have a photo ID? You can vote even if you don't have a photo ID. You still have to fill out an affidavit and attest that it's you. And there's follow-up by, the election officials to ensure that it's you. But you can vote if you're homeless. Voting is so important, and I hope that everybody exercises it, not just, in this election, but in many more to come.
Thank you, Mary and Takura.
Thanks, Lisa. And if anyone wants to hear more about this issue and more, check out our podcast, Constitutional Defenders. It is on every podcast platform imaginable. Thanks.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza PLC. in the name of family law.
Good morning and welcome to our inaugural segment of CPS Defense and Family Law. Today we have joining us Brandy Thompson. She is a partner at the Kronzek law firm in Lansing. And we're going to cover the basics of dealing with CPS today. And what do you do when CPS comes knocking on your door? Brandy has 15 years experience of working on cases for parents in the CPS system. Brandy, welcome to the show.
Thank you, Lisa.
So my first question is, who is CPS and what do they do?
Well, Lisa, CPS is a division of the Michigan Department of Health and Human Services, otherwise known as MDHHS. And CPS is an acronym for Child Protective Services. What Child Protective Services is tasked with doing is investigating allegations of non-accidental abuse, whether it be physical, emotional, mental abuse, and then also neglect of minor children.
Okay, so who can initiate a CPS case against a parent?
Well, unfortunately, the answer is basically anyone. It could be a neighbor, it could be a disgruntled ex, anybody who feels that they want to file an allegation or see something worthy of filing allegation. However, we do see some common themes, reoccurrent types of people who are initiating those investigations. And one of the most common is the other parent. Sometimes people are going through a nasty divorce, a custody battle, having disputes over parenting time, and those sometimes do result in one of the parents filing a complaint against the other with CPS. Another very common type of person to initiate a report are mandatory reporters. Those are people who are mandated by the state to report allegations of abuse or neglect. And these people generally are professionals who regularly come into contact with minor children, such as doctors, pediatricians, therapists, and certainly school teachers, and then also police. Finally, I think that one of the more common are the child themselves. The child may make a statement, usually to a third party, about something that maybe occurred in the home that may rise to the level of abuse or neglect, and either the child, him or herself, makes the phone call to CPS, or as a result of the third party, that maybe that adult will make a call to CPS.
So how will a parent know that CPS is becoming involved with their lives?
There are a lot of different circumstances where CPS might make that initial contact with a family after the allegation has been made. And sometimes that is as simple as a phone call. CPS may contact you, they may leave you a voicemail if you don't answer, and indicate that someone has filed an allegation of abuse or neglect and that they are interested in investigating. They may ask to come to your home, or they may ask you to come down to the Department of Health and Human Services because they want to talk with you. Another way is they may actually show up at your home. They may knock on your door and ask to come in, ask to see your child, check on the welfare, and certainly if they're knocking on your door that there's been an allegation and that they're involved. Some of the more unsettling ones is that your child comes home from school and indicates that they have been interviewed or talked with at school by a CPS caseworker. And if your child is of school age and in a public or even a private school, CPS is permitted to go into that school and talk with your child if an allegation of abuse or neglect has been made.
So do they have to notify the parent before the child talks to a CPS worker at school?
Unfortunately, no. In the state of Michigan, and actually many states, when a child is alleged to be a victim of some type of abuse or neglect, they do not need to notify the parents that they are contacting them at school. They simply may show up and make that initial contact with the child before the parent even knows that CPS is even involved.
So a lot of examples you just provided made me wonder, what are the parents' rights? For example, if CPS is knocking at the door, do you have to let them in, for example? So could you help us understand, what should a parent do if they're in that situation when they find out whether by phone call or somebody knocking at their door or the child coming home from school. What are their rights?
Sure, certainly. First and foremost, I would say if CPS is knocking at your door, remain calm. One of the best rights or the utmost right you have is to contact an attorney to help you through this. So I would certainly encourage that. Stay off Google, and avoid those horror stories, and contact someone who can help you through the situation. But the long and short of it is, when people ask, do I have to speak with CPS? Do I have to let them see my children? Do I have to let them interview my child? Or do I have to let them in my home? The answer is, without a court order, no. You do not have to allow them any of those things. You can certainly shut the door. I always say politely and courteously when you're dealing with CPS, but you are not required to do any of those things. But certainly the second half of that is sometimes, after contacting an attorney, after we contact CPS, figure out what the allegations are, sometimes we realize working with CPS is the best strategy to get CPS out of your life and get through the investigation very fast. Where CPS has been given these allegations, they're simply not true, and we can quickly and efficiently deal with those by working with CPS and allowing a certain level, of interviews and seeing the child. In other cases, certainly we would not allow those types of things. So it's definitely on a case-by-case basis as to what we would end up doing. But your rights as a parent, without a court order that they show you signed by a judge, you are not required to do any of those things.
So some of your comments actually raised a couple of questions for me. One, if they're at your door, will they tell you what the allegations are, or are they more likely to only do that once you have an attorney who's pushing them to share the allegations?
And Lisa, I've heard varied answers. Sometimes CPS is very tight-lipped with regard to the specifics of the allegations. Essentially, they are supposed to identify you via a state ID or a driver's license, and then provide you with the allegations. In all actuality and reality, that doesn't always happen. I speak with a lot of clients on a regular basis who have had contact with CPS, and they still don't have an idea what the allegations are. Sometimes it does take an attorney to sit down, talk with CPS, and ask specifically, what are the allegations of my client? Please read them to us. And then we have an idea of, okay, this is where we need to go, because now we know what the allegations are.
Now, I think both of us can think of examples where maybe things have gone badly when CPS shows up, like the parent is so shocked or angry that maybe they overreact, and that may cause problems later in the case. Do you have any recommendations for the parent who's faced with that?
Yeah, sometimes CPS has a lot of discretion, and if things go badly right off the bat, you may end up in court, or things may progress in a manner that you don't want to. Again, I would recommend contact an attorney, contact someone who has experience specifically in dealing with CPS, such as a firm like mine, and get them in as quickly as possible. We can often pull things back and get things going in a much better direction.
Well, thank you, Brandy. We have a lot more to talk about for the rest of the season, so this was a great start, giving us the basics about dealing with CPS. Appreciate your time today.
In the Name of Family Law is brought to you by the Kronzek firm. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the name of personal injury law.
In 2019, there were major changes made to the Michigan no-fault auto insurance law. These changes passed without any public hearings and through a rushed legislative process. Some say the changes were needed to bring down the cost of auto insurance, while others have found many aspects of these changes to be controversial and troublesome. Today, we're going to talk about a lawsuit pending in the Ingham County Circuit Court that seeks to challenge the constitutionality and enforceability of various parts of the no-fault changes. This lawsuit is being handled by the Sinas Dramis law firm, and we have with us today Stephen Sinas of the Sinas Dramis law firm and his special guest to talk about it. So hello, Steve, welcome back to the show. Before we begin, could you please introduce our special guest today?
Yeah, it's great to be here. It's great to have my guest here today with us. I have my highly respected colleague, Lauren Kissel, who's an attorney at our law firm, and she has been working extensively on this lawsuit that we're going to talk about today. And I'm also very pleased to have members of the Andary family. We have Dr. Michael Andary and his daughters, Michelle Andary and Caroline Andary, and they are plaintiffs in our lawsuit, and Lauren's going to explain that to you. I just had a couple quick comments. Our firm was heavily involved in the no-fault insurance reform debate. We advocated for certain changes. The changes that were implemented were not the ones that we thought were good for Michigan. And we looked at these changes, and there's a time where you feel as an attorney and as in a law firm, you need to step up and take a stand against bad legislation and legislation that has concerning issues. And so we feel that we're doing that in this lawsuit here, and Lauren's going to explain to you what it's all about. So please take it away, Lauren.
Thanks, Steve. So as Steve and Lisa both mentioned, our law firm has filed a lawsuit challenging two specific provisions of the new no-fault law. It's currently pending in the Ingham County Circuit Court, and there are three plaintiffs in the lawsuit. The first plaintiff is the Andary family, who is here with us today. And then we also have the Eisenhower Center, which is a neurological rehabilitation center in Ann Arbor, and Philip Kruger, who is a person who was severely injured in a motor vehicle accident in 1990 and is currently a patient at the Eisenhower Center. This lawsuit essentially challenges two aspects of the new no-fault law. The first aspect is the 56-hour per week cap on in-home family-provided attendant care. And we call it in-home family-provided attendant care just to kind of simplify it, but really it's a 56-hour per week cap on any attendant care provided by people that the injured person knew prior to their injuries. And the second provision that our law firm is challenging is the 55% fee schedule that applies to services that are not compensable under the Medicare fee schedule. So in this regard, our plaintiff, the Eisenhower Center, is severely affected by that because centers such as Eisenhower, who provide neurological rehabilitation services, often are not compensable by Medicare. The main argument of our lawsuit is that the retroactive application of these two provisions to individuals who were injured prior to the date that the new law went into effect is unconstitutional. This is because these sorts of provisions, the rights of these individuals vested at the time of their motor vehicle accidents, and now the government is attempting to go in and change these, how these people can receive their benefits and what benefits these people can receive. The second thrust of our lawsuit is challenging the future application of the in-home family provided attendant care and 55% fee schedule provisions based on equal protection and due process grounds. As I mentioned before, the lawsuit is currently pending in the Ingham County Circuit Court, and we are awaiting a decision from Judge Stokes as to how the lawsuit is going to proceed.
So we have, like you said, the Andary families here today, and I really wanted to hear from them about how these limitations on attendant care are really going to affect your family and what concerns you have about those new limitations.
So right now, my wife Ellen was the person who was injured, and so we have been lucky enough to have a fairly large family and circle of friends and nieces and nephews and my siblings who've all pitched in and have been able to give virtually all of her care since she came home about 4.5, 5 years ago. And so we have been able to give her what I would argue as a physician who takes care of catastrophically injured patients, the best home care that she can get. And it's been all with family or close friends. And so from our point of view, we've been doing this for a long time. Why it's in the state's best interest to kick us out and have strangers come in and take care of her, we think that it's not going to be so good. So you guys want to comment on how this affects Ellen?
Yeah, you go for it. Yeah, I think it has been really great for our mom, who, you know, has always really respected her own privacy and being with her family, and, you know, really respects the family relationship and being with her kids most of the time. And we also love having that bond with our mom. And as challenging as it's been for our mom's recovery, it's been really challenging for us as well. So I think being able to see firsthand our mom's rehab and her recovery, it's been helpful for us to recover as well.
Yeah, our mom has a traumatic brain injury. She doesn't learn new people's names. So if we're not able to care for her, strangers coming into the house, new strangers all the time, she's not going to learn any of their names. They're not going to understand what she's saying half the time. If we thought strangers, and if research backed the fact that strangers take better care of catastrophically injured people, we would have done that 6 years ago. But the fact of the matter is we take better care of our mom, and she's more comfortable with us.
And if I may add, this rule that was passed by the legislature was passed in the name of trying to limit alleged fraud that was going on with people claiming care they're providing to family members. And the insurance industry was saying that there's too much fraud. So we now have to impose a rule that says that families like the Anderys, who suffer the most severe type of brain injury, who provide dedicated care, now can't be compensated, and now it must bring strangers into their home because we had a fraud issue. And this is an example, I think, where the legislature could have combated the issue of fraud in a much different way than taking that right away from the Andery family. And to make matters worse, the fact that they take the right away when it was already established under a private contract between the Anderys and their insurance company makes it all the more egregious. And that's the real rallying cry of our lawsuit here.
Can I just ask, what does 56 hours mean to your family? What is that? How does that work into your lives?
It's ridiculous. I mean, it is irrational and makes no medical sense as a physician.
Egregious.
We've had this. I mean, we bought this. And so why is it in the state's best interest to kick my family out and make Ellen be taken care of by strangers? It makes no logical medical sense. I'm a physician. It makes no emotional sense to our family. It makes no emotional sense to Ellen. And we bought something else. So I don't understand why the state found that to be important. And why not 57 hours? I mean,
and we can't guarantee we're going to win, but what they're saying is the real reason why we're behind this case.
Yeah. Well, thank you all so much for joining us today. This has been really helpful, and especially meeting the Andery family. We really appreciate you joining us. Thank you.
Thanks for having us.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm.
Thank you for watching In the Name of the Law. We look forward to seeing you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.